Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in my previous class we have discussed one of the important concepts from CPC, that is res sub judice, which is section 10 of CPC. In my today's class we are going to focus on section 11, which is again one of the interesting concepts from CPC, that is res judicata. This is covered in part 1 of CPC, which is all about suits in general, covering from section 9 to section 35B. We are going to understand the concept of res judicata, the important maxims that are related to res judicata, the important case laws, and we will also understand when res judicata is applicable and when not. Why to waste time? Let's get into the first slide. This is my master slide for res judicata. Here there is an image with 5 boxes, and if you can remember those 5 boxes, your answer is done as far as section 11 res judicata is concerned. It says no court shall try any suit or issue in which matter is same, parties are same, title is same, and it is already heard by a competent court and decided by a competent court. So if all these 5 aspects are satisfied, in that case the case cannot be taken again to another court. That is what all about section 11. Now when we are saying matter is same, it can be directly or substantially same matter, or when we are saying that fifth aspect, that is decided by a competent court, there should not be any opportunity for appeal, or the appeal is already decided. In all those cases, no court shall try any such suits or issues. I will repeat the 5 aspects that we need to remember is matter should be same, parties should be same, title should be same, and it should be heard by a competent court, and such court has already decided that decree, and there is no appeal lies, and appeal is already decided in other case if there was any opportunity for appeal. Now that's all for section 11. Now the word meaning of res judicata is a matter that has been adjudicated by a competent court and therefore may not be pursued further by the same parties. That is the word meaning, and that's for section 11. I have many more details in my future slides. Let's get into other slides. While studying res judicata, we need to understand 3 important maxims which are considered as the background for res judicata. Before even I get into those 3 maxims, let us try see the meaning of res judicata. It is a matter adjudged, or a thing judicially acted upon or decided, or a thing or matter settled by judgment. That is what the meaning of res judicata. And then we have 3 important maxims. The first maxim is nemo debet bis vexeri pro una et idem causa. Now the meaning of that particular maxim is no man should be vexed twice for the same cause. That is the very base for section 11. Now if a same man is vexed again and again, or given problem again and again for the same case, then it is not good for anyone. Even after the decree is passed and decree is in favor of him, if the case is again heard, then it is not good for anyone, and that becomes the base for section 11. The next maxim says interest republicae ad sit finis litium, which means it is in the interest of the state that there should be an end to a litigation. If that doesn't happen, it is harassment of court's time, it is harassment of another party, which is not good for the state. So every litigation should have an end, and that is very, very important for any state to have peace. So in the cases of civil case, there should be end for any litigation. That is why this theory, that is the doctrine of res judicata, is very strongly implied via section 11 of CPC. Then comes the last maxim, which says res judicata pro veritate occupitur. That means a judicial decision must be accepted as correct. Now if people start challenging every other decree given by the court, then that will not end anywhere. So a judicial decision must be accepted as correct. Now if I have to read all 3 of them, it should be no man should be vexed twice for the same cause. It is in the interest of the state that there should be an end to a litigation, and then a judicial decision must be accepted as correct. And finally, I am giving one additional information with the form of Roman law, which says ex capitero res judicata, which means one suit and one decision is enough for any single dispute. So if there is one suit, there should be one decision which is enough for any single dispute, which is what Roman law has to say. As far as res judicata is concerned, one of the most important case law is Satyadan Ghoshal versus Diorjin Debi. Here in this case law, Das Gupta J has explained the doctrine of res judicata. He said the principle of res judicata is based on the need of giving a finality to judicial decisions. What it says is that once a res is judicata, it shall not be adjudged again. Primarily, it applies as between past litigation and future litigation when a matter, whether on a question of fact or on a question of law, has been decided between two parties in one suit or one proceeding, and the decision is final either because no appeal was taken to a higher court or because the appeal was dismissed or no appeal lies. Neither party will be allowed in future suit or proceeding between the same parties to canvass the matter again. Here in this doctrine, he explains completely that where and all res judicata is applicable. He says it applies for past and future litigation. He says it is applicable for both question of fact as well as question of law. And when it comes to the matter of appeal, if the appeal is dismissed, then res judicata is applicable. If appeal was not taken, then also res judicata is applicable. When I am saying not taken, there is time given for every appeal, and if the time is barred as per Limitation Act or any other provision of the law, then there also res judicata is applied. Or in case of there is no opportunity for appeal itself or no appeal lies, in that case also res judicata will be applied. Now the next simple question is whether res judicata is applicable for writ cases. Yes, it is applicable for them also, which was held in the case of Dario Singh versus State of UP. And one important thing that you need to remember is, as far as writ is concerned, there is one exception available, that is for the cases of habeas corpus. Section 11 has given few important explanations and I have brought few among them. First being, what is former suit? Suit which is already been decided and brought again is known as former suit. It is already been decided and brought again. The second aspect is, what is competent court? Competent court is the court which is competent to hear that particular case. The third one is matter. Matter is former suit which is alleged by one party and denied or admitted expressly or impliedly by the other. Here one party made an allegation and the other party either denied or admitted, and it may be in the form of expressed way or maybe implied way. That is known as matter. The next term is matter directly and substantially is same. If in any matter which might and ought to have been made ground of defense or attack in such former suit, and if it is brought again in front of the court, and if it is almost same as the previous case, then that is known as matter directly and substantially is same. The fifth one is refused. Any relief claimed in the plaint which is not expressly granted by the decree. Now in the decree there can be grant or that can be refusal. If it is refused, that is refused. The last part says an issue heard and finally decided by a court of limited jurisdiction competent to decide such issue shall operate as res judicata in as subsequent suit, notwithstanding that such court of limited jurisdiction was not competent to try such subsequent suit or the suit in which such issue has been subsequently raised. That is the last part. Overall, what is that you need to remember is res judicata is all about a case which is been already heard or already been decided. Once after decided, once after the decree is given, if there is an opportunity for appeal, excellent. If there is no appeal lies or if the appeal is not taken within the time available, in that case the same case cannot be taken to any other court, which is all about res judicata, which is all about section 11 of CPC. With that, I'm taking off from this particular session. See you in my next session. Thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you're watching my videos, and thanks again.